All right, hello everyone, and welcome to Personnel Records. Presenting today we have Anniken Davenport, a noted employment law attorney and editor of HR Specialist Employment Law. Anniken has served as a professor at Penn State University where she taught business law and HR management, and she is co-author of the upcoming Labor and Employment Law for the 21st Century. Her presentation today will last about 1 hour, and we also have some time reserved to answer questions from our audience. So to everyone in attendance today, please type any questions you have into the questions panel, and then we'll try to answer as many as we can after the presentation. So welcome, Anniken. The floor is all yours.
Thank you so much, and welcome everyone. I'm really glad you decided to join me today. Before we get started, just a reminder, this is an educational session and it's not direct legal advice. So here's some of the things we're going to talk about today. I don't know about you, but my office is full of paper. And I do have a plan for retaining records and getting rid of what I don't need. But sometimes it feels a little overwhelming, or, I'll delay running the shredder for a little while and then it piles up again. So I feel your pain. Let me just put it that way. So we're going to talk about the best way to really manage everything in a way that means that you have what you need when you need it, but you don't have more than you need. And it's relatively simple if you're just an individual keeping track of your own records, but it does get a little more complicated when, you really are in charge of an organization's records, and when those records may be needed at some point in the future. So we're going to take a look at what you need to keep, why you need to keep it, and what you can safely get rid of. So I'm really thinking in terms of creating a plan for you that lets you determine for yourself what needs to go and what steps you really do need to take into account. And, the safe approach theoretically is to keep it all, but really that is wrong, even if you are keeping things not in paper form, but in electronic form. So essentially, it's a 10-step plan. And we're going to start by reviewing the federal requirements. What is it that the federal regulators, various agencies, require you to keep that you really can't get rid of until the date that they give you to get rid of it? We're going to take a look at that. What do all the major players in this arena require you to do? And then you're going to go further than that, because you're not just governed by federal agencies. You're going to have to take a look at your state and your local agencies. Now, obviously, today we don't have enough time to go through every single state and local requirement for record keeping, but you should be aware that you need to add them to your checklist. And you may have to go directly to them to say, okay, what is it you need me to keep? What can I safely get rid of? And there are a couple of HR-related state functions that really are exclusively state functions largely. And among those are workers' compensation agencies who typically are going to be located within your state's labor department. And they're going to have some specialized rules as to what paperwork you need to keep too. And then we have big cities. If you're operating in a big city, like New York, San Francisco, Seattle, those kinds of large areas, they're going to have their own agencies with their own wage and hour rules, their own safety rules, their own anti-discrimination rules, and they may have slightly different rules. So always check with them too. And, one of the big things, step 3 of our plan, is that you have to determine which documents you're most comfortable keeping in paper form, which documents you're more comfortable or even required to keep in electronic form, or both. You're going to have to make some decisions on it as to how you're going to manage all this. And, in some respects, the old keep it in paper actually can be more hazardous. And you really need to be aware of the possibility that some documents are going to be lost through fire, through water, through other natural disasters. But that's also true for electronic forms of document keeping because new technologies do advance. So floppy disk, anyone? Can you even access something you stored electronically on a floppy disk? And if you don't know what a floppy disk is, then you're much younger than I. But certainly I use those, and I would not know what to do if presented with a floppy disk today because I have absolutely no method that I can use to access that information. So essentially what I'm saying is step 3 is back up your backup. Have a backup plan to your backup plan. You're also going to have to take a look at what the rules are for keeping something electronically. If an agency says you can keep something electronically, are you required to keep a paper backup? Or is there a system by which you can automatically back up documents that you keep electronically? There certainly should be. You don't want to lose that electronic record entirely. And this depends on the type of record you're talking about, but it also depends on what state rules there may be in place for security. How do you protect information you keep, say, off-site in a cloud storage system, or that you keep off-site in a box? How do you protect that information, whether electronic or paper, from being confiscated, from being hacked into, whatever the case may be? And what are your obligations to protect that information? And then again, step 5, do you have oldish records in electronic format? Can you retrieve them? Do you have a paper backup? So let's say that you placed your DOL required records on floppy disks. Is that technology dead? There are certainly services that can help you retrieve that kind of information. Services that specialize in doing exactly that. They have the equipment to take a look at an old floppy disk or its predecessors and can receive that information, can retrieve it for you. But that's not a position I think you would like to be in because those service providers are few and far between, and they tend to be entities that kind of serve as the legal profession, and they are quite expensive to use when you have to pay them to go ahead and tell you what is on your record. So part 5 of your plan should be to have in place a routine analysis of your technology. What I've seen happen in some cases is that a company will have records in an electronic format, whether that's the little drives that you might hook up into your computer, or whether it's the floppy disks, whatever that case is. And then when they upgrade their technology, they don't necessarily think about, okay, do I need to move all this information to my new technology? So that should also be on your horizon when you're coming up with your plan for record retention. How exactly and when exactly are you going to move the old records from the old record format to a new record format so that you're keeping up with the technology and you're able to retrieve the information? Another thing you should be asking your IT staff is, as you're thinking about your electronic records, is how should I be saving the information? In what format should I be saving it? We have all been using PDF for a very long time now, and I think the temptation is to think that, oh, well, if I save something in a PDF format, I'm probably always going to be able to retrieve it. You may be right. Yes, PDF formats are, pretty universal and have been around for a very long time, and somebody's probably going to be able to read that document at every point in the future. But what about software upgrades? When will software updates end for the system you're using? And if it does end, or if the support stops, then it's not going to be as easy to retrieve that information. So again, you'll keep up on that kind of information. I discovered this the hard way when I went to retrieve something from a laptop and the system crashed, and it told me I had to, install the latest version of the operating system. And of course I could not do that because it wasn't being made anymore. So that made for a tricky situation where I still needed to get those records. Fortunately, I had actually backed that up in a cloud format, and I was able to retrieve that. But if I hadn't had that automatic backing up, I would have been unable to retrieve the information because I couldn't update the computer on which it was kept, where my primary copy was kept. And you also really, really, really have to think about personal information. More and more and more states, and in some cases cities, are coming up with rules for employers as to what steps they must take to protect sensitive information that is in their possession. And, I really think it's incumbent upon you to, one, follow all the rules about what documents you have to separate and put in a storage system that is only accessible by those who need access to that information. And then there's just the physical aspect of locking up files. You should be maintaining paper files in a locked cabinet where access is restricted to individuals whose official duties within your organization are really to access that kind of information. You should be doing the same thing with computerized records. And certainly IT can work with you on that in order to set, logins and passwords and so on, so that the only individuals who, need access to that information will access it, and that outsiders can't access it. Now, I can also tell you that this is an increasing problem with employees who work from home. How much control can you, as the employer, exert over how they maintain their files and who else has access to those files? Is your teleworking employee working in the family room? And does your employee get up to get a drink of water? And then a child or a guest could look at the information they are displaying on their computer screen. All those are practical considerations that you should be thinking about when you are thinking about how to maintain your records and how to limit access to them. So there are rules you can put in place that basically say to your employees, okay, you have to log out anytime that you leave your equipment on and in an area that can be accessed by other individuals. So you should set those rules in place in your teleworking agreement. And if you don't have a teleworking agreement, I'm here to tell you, you really should have one in place that really specifies a whole host of things, including limiting access to files, whether electronic or paper, for people who work at home or from other locations. It's particularly risky if you allow those individuals who telework to work from a location where there is easy access on the part of nefarious parties to the kinds of information that may go with a laptop, for example. Working at Starbucks is not a good tactic for protecting information, even if you are logging into what you believe to be a protected system. Step 7, have you carefully looked over all medical information that is in your possession and separated anything remotely medically related into a confidential file to which you also limit access. If not, you should be doing that right now. So what do I mean by medical records? I mean any information that relates to any illness, any medical condition, whether physical or mental, or somebody's genetic information. So billing information for insurance can reveal a whole host of things. If somebody knows what to look for, like billing codes that tell you exactly what condition an individual may have or is being screened for. All those requests for FMLA leave that are based on a serious health condition, all the information supporting the serious health condition request, leave request, is going to be medical information. When somebody requests a reasonable accommodation for their disability, that's one that likely is going to include a lot of medical information. And of course, anything related to pregnancy. And that's an increasing problem right now because we have a brand new law that says that any condition related to pregnancy requires that an employer provide a reasonable accommodation if that's what's required for the individual to continue performing their job. So you're going to be coming into contact with much more medically pregnancy-related information than you ever did before, and that needs to be segregated. Workers' comp information, that obviously deals with workplace injuries, so that's going to be medical information. And then any other record that you may have that could conceivably reveal a disability or a serious health condition or a genetic piece of information or other sensitive medical data. And the genetic information is a relatively new problem. Employers didn't used to have access to that kind of information because very few people had access to that kind of information. But that is showing up more and more and more in insurance claims, for example, where somebody may have been screened for a particular condition or tested positive for a particular gene as a part of their diagnostic workup, becoming more and more common. And there's a special law that protects that information called the GINA, the Genetic Information Non-Discrimination Act, which actually has resulted in at least one huge jury award for an employer who required access to that information and then used it in employment decision making. And then number 8 of your plan. Have you informed everyone who might come into contact with a request for records from an outside entity what they're supposed to do if they get that request? So every employee should understand exactly what to do about releasing information, and that this information should not be released without prior review from HR to determine whether or not the record request is legitimate, whether it is legal, and whether the records are confidential. And in addition to that, you need to have a system in place that tracks exactly where records are at any given time. Where did they originate? Where did they go? Were copies made? Who signed them out? And who received them on the other end? And did they make their way back to you? You got to track that very carefully because at some point you might be asked for those records, and you have to be able to show that they really are the records that you originally generated or came into possession of. And then, and this is from a lawyer's point of view, a pretty crucial thing. Do you have a plan in place to retain every record, even records that are sitting right there by the shredder about to be shredded, the very moment your organization receives notice that there may be a lawsuit coming, or there's an agency inspection coming, or there's a potential for that even at some point in the future, i.e. an employee comes to you and makes a claim of some kind of discrimination. The moment you know that somebody is potentially going to sue you, you need to have a plan for not destroying anything that could be even remotely relevant to that potential lawsuit. And it is really crucial. You need to be able to order an instant stop to any automatic destruction method that you have in place, like automatic email deletions, to the resetting of electronic devices like phones or iPads and so on. You have to be able to stop that. And it has to include stopping the destruction of anything that could conceivably be related to the threatened lawsuit or the inspection or the complaint. And yes, that includes text and messages, whether they're sent and received on company-owned and controlled devices, on company email, or on an individual's personal devices or emails. Now that is the trickiest one. If you allow individuals to use their personal devices to conduct business for you, then you have to get their agreement to preserve any communications that they use those devices to send or receive in the event that that information is going to be needed. Or just that information is, legally protected for privacy reasons or whatever the case may be. But you have to, before you permit individuals to download information that is your organization's information, or to send messages back and forth, you have to have a way to stop that from being deleted. And that's a tall order, particularly because there's a lot of employees out there who prefer to use their own devices specifically because they believe that practically being able to use their own personal devices means that they can also control access to that information and hold back on releasing it or destroy it at their discretion. So talk to IT about how you can structure a way to either block access by all personal devices that are not company owned and operated, and what you can do, how they can send messages out to say, this is a destruction hold. You may not destroy any information on those devices. Why is this so important? It's important because if once you have notice of a potential claim, you destroy any information that could be relevant to that complaint, a court is likely to say that the fact that you destroyed it may have an implication that the information was beneficial to the individual who's suing you. So not a position you want to be in. And 10, have you marked every document or file with the appropriate retention date? This is, what we refer to as a best practice, but in reality, it's pretty hard to follow. But you should make an effort to mark those documents. You can take a cue from the federal government. You'll see that on every federal government form, there is a retention date, and a date by which the form can't be used anymore. So you'll want to kind of try to develop that practice. And you may want to stick that in a footer or something, but it should be fairly obvious to everybody who is in possession of that document that when it should be retained and for how long it should be retained. So let's shift into taking a look at specific records that you need to maintain as part of your personnel files. The first law we're going to look at is the Fair Labor Standards Act, which is the kind of granddaddy of all the labor laws at the federal level. And we're going to look at the wage and hour rules that are in the FLSA and what you have to keep. The FLSA sets minimum wage, governs when you pay overtime, sets the rules for payroll and employment records for hourly employees. And those employment record retention rules are there because DOL, which administers the FLSA, wants to be able to see that you as an employer paid your employees for all the time they worked, and that your calculations for how much you owe them at the end of the work week or the pay period actually is backed up by documents that show that the individual worked or didn't work during relevant times. It is your responsibility as the employer to keep track of an employee's hours worked. And, you really, if you ignore this rule, you do so at your peril. If you don't have records to back up how you calculated somebody's pay, how many hours they worked, what their hourly rate was, etc., then, if you have an employee who alleges that you underpaid them, if you don't have the records to back up how you did pay them, then the court is going to rely on whatever reasonable calculation the employee may have come up with. DOL may also levy fines against you for not keeping your records appropriately. But DOL also puts out a couple of apps that anybody can download in order to track their hours, and this app is pretty slick. It will actually calculate based on, you putting in the hours worked, putting in your hourly rate. It'll generate what your paycheck should look like. I know increasingly employees who claim they're working more hours than their employer is paying them for will pull up the information from that app in order to try to persuade DOL that indeed they have been underpaid. So be aware that is out there. And your records better match. There's a timer component of that too, so you can actually turn it on and turn it off to keep track of that time if you're the employee. So what kind of records do you have to keep under the FLSA? For every non-exempt, i.e. hourly worker, you have to keep all the records that back up what you pay them. Unfortunately, the law doesn't say exactly what form those records are supposed to be in. That's up to you as the employer to determine how you're going to keep track of this stuff. It does, however, require that there be certain identifying information about the employee in those records, such as their identity and data that supports the number of hours or minutes they worked and the wages they earned. And then, of course, the law requires that the information be accurate. And this is the basic information you have to keep on every employee. Full name and social security number, and of course you want to make sure that you're keeping the social security number in particular confidential. And the social security number in conjunction with somebody's full name is likely to be a valuable commodity in this time of identity theft. So you'll want to make sure that you keep that information basically under lock and key. It also requires you to keep the address, including the zip code. You only have to note somebody's birth date if they are younger than 19. If they're older than 19, you don't have to keep the birth date. Their sex and their occupation, the time and day of week when the employee's work week begins, and this has to be consistent from week to week in terms of the work week itself, not the days that the individual may work, but what is considered a work week needs to be consistent. And don't even think about doing what the mayor of a town in which I lived for a while, actually a long time, who was also the owner of a bookstore. His employees accused him of basically manipulating the work week in order to avoid paying overtime. And allegedly what he would do is he would say that this week your work week begins on Tuesday, and then the next week it might begin on Monday, and it all depended on how many days he had the employees working that week and whether they then would hit 40 hours or more and thus be entitled to overtime. So don't play with the work week. The work week is the work week. You can obviously change it at some point going forward, but it had better continue to be that for a period of time after that. You have to track the hours worked every day. And that includes, even if there's a split shift, if somebody comes in and works 4 hours in the morning and then comes back 4 hours later and works another 4 hours, you have to track that. And of course, you have to have a record of the total hours worked each work week, because that's going to determine whether you pay them overtime or not if they're hourly. Other things that you're supposed to keep are the basis on which wages are paid. So you're going to say whether they're being paid $4.40 a week or $9 an hour or whatever the case may be. And there are limited options, of course. What their regular hourly pay rate is, that's what you paid them for the first 40 hours. Any total daily or weekly straight time earnings, if you use that, and we're not going to get into the details. And then, of course, the total overtime earnings for the work week, which is done by taking the regular hourly rate times the number of hours up to 40, then plus time and a half for anything over that in the work week. Now, you also have to track deductions from the employee's wages. And this is an area where you also have to be very careful about state law. Because although federal law will allow quite a number of deductions from wages, a lot of states are far more restrictive. And of course, the total wages paid for each pay period and the date of payment and the pay period covered by the payment. Essentially, you're required to keep enough information so that DOL can determine whether you paid employees properly, what they were supposed to be paid, what they were supposed to be paid in regular and in overtime, and what dates they were paid. So the FLSA doesn't make any requirements as to how you keep these records. And it means you can keep them in electronic or paper-based forms or both. And they have to be, whatever you do with these records, wherever you keep them, they have to be accessible to the DOL within 72 hours notice. You have to have a file on each hourly employee that includes the basic information about their pay, the position they held, the date they were hired, the date they were promoted or terminated, whether they had a break in service. And you have to also keep a record of the dates of absences and any pay they received for those absences. Now here's the question. How long do you have to retain these records? You must preserve them for at least 3 years. And that's payroll records, collective bargaining agreements, sales and purchase records. You have to retain these for a minimum of 3 years. And then there's another set of records you have to keep for 2 years, a little less. And those are the records on which you're calculating that paycheck. So what would this be? Time cards, wage rate tables that show what you're paying at any given time, work schedules to show when people were scheduled, time schedules to show exactly where they worked, when they worked. And then if you're making deductions for taxes, insurance, and other things like child support or defaulted student loans, you have to keep track of that too. So all these records have to be open for inspection should a DOL investigator ask. And the DOL inspectors can require that you provide them with copies. And they do have rules for where you keep these records in whatever form you choose to keep them. And they can be kept either at the place of employment or at some sort of a central records office, which means that if you're keeping everything electronically and you put it in a cloud account, that would be the central records office. Or it could also be a physical place if you have a location where you keep all the records. So for routine inspections, DOL is going to give you 72 hours. But if the circumstances warrant, DOL may also conduct an unannounced inspection. And this would be that rare situation where they believe that they have evidence that perhaps you are not being quite upfront with either working conditions or record keeping. And they will want to see some kind of a document control log. And you should also be able to show exactly when your records were generated and where they were kept and who has checked them out. So let's talk about another kind of record under the FLSA, timekeeping. You can use any timekeeping method you want to. So if you want to use a time clock, that's fine. If you want to have somebody at the front desk checking people in and out, that's fine too. Or you can even tell workers to write down their own. That's generally the least reliable and the most subject to, shall we say, manipulation. My personal preference is if you have people physically coming in, it would be to use a time clock. That's going to be generally the most accurate. If you have people working remotely, it should be some kind of a computer sign-in. But any timekeeping plan you come up with is going to be acceptable to DOL as long as it is, accurate and complete. And we talked about that app before, but you may want to check out that app. Your employees are likely at least spot checking that they're being paid appropriately. So you might as well use the same app to double check your own calculations to see if you're getting it right. And then the question I often get is, well, what about exempt employees, salaried employees? Am I supposed to track their time too? And generally, no, you don't need to track their time unless you feel the need to track their time. As long as you are paying them on a salary basis and you're not deducting from their pay because they clocked out 15 minutes early, you can track the time. Just don't use it to generate that paycheck. But you do have to keep basic information on them too. You certainly should have records that substantiate that they are appropriately classified as exempt, and that can include things like their job title and their job description. For all practical purposes, it really makes a lot of sense to retain all the same information for exempt workers as you do for hourly ones. And the reason for that is, what happens if somebody you've classified as exempt goes to court and says, oh, we should not be classified as exempt. We should be classified as hourly. And then what if a court says, oh, employee, you're right, you are really an hourly employee. Now, you, the employer, are going to be liable for any overtime that they worked. Well, how will you be able to say how much overtime they worked? You don't really want it to be their word against yours. So if you've kept track of their hours anyway, you can easily figure out whether they were due any overtime at all, and if so, how much they might have been due. You're going to look a lot better to the judge, even in a misclassification case, if you can figure that out and you can, make an offer of paying them what they're owed. So switching over to the IRS, they have payroll record requirements too. And their focus is a little different. It's on being able to determine exactly what the proper tax withholding was supposed to be. Their interest is, limited to taxation, really. And lately, they have been hyper-focused on making sure that you don't have people not classified as employees, but instead have them classified as independent contractors when they really should be employees. So they're very sensitive to that. They are looking for violations. Why are they looking for violations? Again, their emphasis is on tax collection. And individuals who are classified as independent contractors are responsible for their own tax withholding and submission. And from experience, the IRS has learned that independent contractors aren't as good about getting that revenue in there, as an employer is when they're just withholding from an individual's pay. So they're highly suspicious of classifying individuals as independent contractors and are really scrutinizing whether you have that right. You need to keep all records that the IRS wants you to keep, at least for 4 years from the date that something was due to be filed with the IRS, or when it was actually filed if you're negligent in your submission of those kinds of records. And here's additional information that they want in order to substantiate that they have all the taxes that they were due from employees and from employers. And then there's additional information that they want, in addition to what the FLSA requires you to keep. They want to know when people were employed by you, any copies of W-2s that were returned to you as undeliverable at the end of the year when you sent them out, periods in which somebody was paid because of their absence. They want to know all the dates and amounts of any tax deposits you made, copies of company tax returns that have been filed, how you calculated somebody's allocated tips, any records of any fringe benefits that individuals received. Now, they also want federal and state payroll tax deposit forms, and you have to keep all payroll records for the duration of time that is local or a state government wants you to keep them to, and certainly proof the payment of those taxes. And that can be anything from a deposit slip to a canceled check, and so on. Let's talk about DHS and Form I-9. Essentially, DHS, Department of Homeland Security, has employers be a partner in enforcing the nation's immigration laws. And that partnership involves you, as the employer, being required to identify the individual who's coming to work for you and their work authorization within the country. And that's true for both citizen and non-citizens. And the form has to be filled out no later than the day that they start working and signed by the employee. And then within a few days after that, you as the employer have to review their documentation. It can be paper or electronic form, but it has to be readily accessible to ICE. And for a period of time during COVID, you could remotely examine these documents if you hired remote workers. That is no longer the case, with one very limited exception, and that is if you agree to participate in the federal government's E-Verify program. And that's essentially a database match for individuals who present with a Social Security number, and the system will cross-reference names and so on to make sure that the individual is who they say they are and has valid work permissions. So you're obligated to examine an individual's eligibility and identity documents through the use of Form I-9. Just a caution for all you here, we're in the first week really of November 1st, there's a new I-9 form that has to be used. If you're using an older version of the form, you need to switch right now. And again, as I said, November 1st is when you have to use this new form. The temporary remote hire rules are gone. They ended July 31st. You had until August 30th to physically re-examine all these documents. And if you didn't do that, I think it's a good idea to call your lawyer and explain why you didn't, and fix that problem. And also, if you do sign up for E-Verify, then you're going to have probably a fairly easier time and be more comfortable with how you are handling all the documents that deal with somebody's identity. Because essentially the E-Verify system lets you enter information into the database, and then you will get back from the federal government a match or a no match. If the documents match what they have on their records, you're pretty clear. You have not hired somebody who is not authorized to work in the country. If you get a no match, there are also instructions that come with that you give to the employee. And at that point, the employee is the one who has to fix the problem. It never becomes your problem to fix the problem of that mismatch. The employee has to do it and report back to you within a very tight time limit. And then the system is also going to kick back either whether that was a successful effort on the person to clear their eligibility or not. And at that point, you're free to terminate the individual if you have a mismatch. But it really takes a lot of the hassle of making sure that documentation is correct out of your hands because you get this match or mismatch. So I highly recommend thinking about signing up for E-Verify. And particularly if you are going to continue to hire remote workers, because that is now the only circumstance under which you may document somebody's authority to work remotely. If you signed up for E-Verify and you are following the rules under the E-Verify program for examining those documents remotely. If you don't use E-Verify, you can no longer use remote examination for your remote workers at all. We had all hoped that because we thought things were working pretty smoothly with the distance matching of records, that DHS would decide, oh, this is working fine. We don't have to drag people, into an office to examine these records. But they didn't go with that. They took it as an opportunity to try to encourage more employers to use E-Verify. So that's the status of that. So what do you do with the records if you are you have all these records that you've generated from the individual? You need to keep the actual Form I-9 for as long as the employee is your employee, and another 3 years for that from the date of hire, or 1 year after the date the employment ended, whichever is later. There's an example there for you. You may photocopy the supporting documentation, and you have to sign a form showing that you inspected the documentation as part of the I-9 process. That's on the form. There's also a question of re-verification. If you have employees who have temporary permissions to work, essentially, you're going to have to track when their documentation expires and then be able to get the information re-verified. And I've included a link here for you to DHS as to what the rules are for this re-verification. This is particularly important if you have individuals who have work permissions under DACA. They will continue to accept and process those renewal applications. They will not process new applications. But those documentations have to be renewed regularly, so you have to keep on top of that too. You have to have a tickler system whereby you go back and say, give me your new form. What are some of the penalties? DOL charges $10,000 or more, or imprisons you for up to 6 months if you don't follow the record retention rules. IRS is much steeper. And they get steeper depending on the kind of violation you've committed. And it can get pretty hefty. Department of Justice handles DHS, I-9 violations, and these two can get pretty hefty if you willfully basically ignore your role as a partner with ICE in making sure that you're only hiring individuals with work permissions. Let's take a look at the EEOC, the next big federal agency that requires a lot of record retention. They're responsible for enforcing a whole host of laws, including Title VII and the ADA and the ADEA. They require you to keep the personal records for at least 1 year. If the employee is fired, then it's 1 year from the date of termination. And if you're an educational institution or a state or local government, it's 2 years. Obviously, for other purposes, you may have to keep records much longer, but that's what they have in place. That doesn't mean you destroy it, because under one law you could. You got to keep it for the longest period of time that a law requires you to keep similar information. So what do they consider personnel records? Requests for reasonable accommodations, applications, records dealing with hiring, promotion, firing, transfers, and so on. Anything that determines pay. If you still have a lot of COVID records laying around, you have to keep them confidential as you would any other medical records. Most of us have wound down these kinds of things and are not terribly worried about it anymore. So this is kind of an area where you can certainly selectively remove some sensitive information that you don't necessarily need anymore. The reason a lot of employers have a lot of these records is because for a while there it looked like you were going to have to force your employees to be vaccinated and so on. And there were special rules for people returning to work and everything like that. But a lot of that is gone. So it's a good thing to go through your COVID-related records and see what it is you can get rid of that you no longer need. The ADA. Somebody who makes a request for a reasonable accommodation is going to generate information with medical information. And so you want to make sure you keep that private. Also, please understand that you cannot disclose disability information to an individual's coworkers or other people who do not have a need to know that information. That is confidential. Just the fact that somebody is claiming an ADA disability and reasonable accommodation is a confidential piece of information that may not be disclosed. I also want to talk a little bit about the Pregnant Workers Fairness Act, a brand new law, went into effect this year. And basically, it's going to generate more requests for reasonable accommodations, but under a different law than the ADA. That needs to be kept separately too and confidential. And again, you can't disclose this information to people who have no need to know. And there are coming regulations dealing with the Pregnant Workers Fairness Act you'll want to be on the lookout for, because they may have there may be additional record retention requirements in the final version. There's also the Equal Pay Act, and this one gets a little trickier because of amendments to it over the years. But essentially, the law says that you have to pay people the same regardless of their gender or their sex, but there are some reasons that you could pay somebody less, and that has to be a factor other than sex. So how do you determine all that? You have to keep the appropriate records to show why you're paying people what you're paying them. And there was a Supreme Court decision under the Equal Pay Act against a woman, Lilly Ledbetter, who said that she had been discriminated against a couple of decades before she filed suit. And her argument was that she didn't have to go to court right away, but that every single paycheck that she earned basically became a evidence of continued discrimination because of the discriminatory promotion she got that didn't get her as much pay as a male, and that every single paycheck is basically a reiteration of that discrimination. Supreme Court said, no, you have to file your EEOC complaint within 180 or 300 days. So what happened was the Lilly Ledbetter Fair Pay Act went right through Congress, and it says that it doesn't matter when the discriminatory compensation decision was rendered. Each paycheck is further evidence of that discrimination, but we're not going to let somebody aggrieved go back, say 30 years. We're going to limit that to 2 years going forward. But the practical effect of that decision is any pay records that you have, that law is that any pay records that you have to retain pretty much indefinitely for current employees. So don't purge any old pay-related records for your current employees because they may be needed to substantiate that you did not discriminate on the basis of sex at some point in the past, which means you may be keeping records for 30 plus years. Let's talk a little bit about GINA, Genetic Information Discrimination, Non-Discrimination Act, EEOC administered, and essentially what it says is that you can't use, require, or purchase genetic information and use that in any kind of employment decision. You may come upon it innocently, like when there's an ADA request for accommodation or something, or you may just overhear information about somebody who just took an ancestry test. So getting the information innocently isn't a violation, but asking for it intentionally is. And I think that a classic example of that is a warehouse down in Georgia where apparently somebody was defecating in the warehouse and the managers wanted to know who was doing that. So they singled out what I would term their usual suspects of prankiness, and they required them to have a cheek swab, and then they tried to match it up with the poop, and there was no match. But the gentleman went to court and asserted that this was a GINA violation because their employer was compelling them to disclose genetic information and wanted to make a decision based on that genetic information. And they got a multi-million-dollar jury award. So be aware of GINA. You don't want to run afoul of it. DOL requires a whole lot of records too. And in particular, OSHA, they want a log of occupational illnesses and injuries going back, 5 years, medical exam records, substances that include exposure to toxic substances, 30 years. And there's also reporting requirements in case somebody dies or is hospitalized or has an amputation or loses an eye. USERRA is another very tricky record retention law, and it's tricky because of the requirement of USERRA. It's the Uniform Services Employment and Reemployment Rights Act, and it protects people who are in military service. And essentially what the law says is that somebody who goes onto active duty military service and then returns is entitled to reinstatement. And if they would have earned a promotion or a pay raise while they were gone, they are still entitled to that even though they were not there. So for those employees, if you know they're been activated to service, you really need to keep their employment files active and make any notations of what they would have received had they remained with you, not on active duty, so you can calculate what they are owed. FMLA. You need basic payroll information. You need information on how you apply their FMLA leave. when you designated something as FMLA leave, and when they took that leave. And any information, if it's medical information, it obviously also has to be kept confidential. And again, some of this you can review at your leisure, but some pretty distinct requirements. Also, I want to talk about personnel file requests. There's no federal law that allows workers to access their personnel files. However, there are a lot of states that do. And some limited it to like once a year. Some limited it only to current employees, not employees who no longer work for you. But there's a link here to the whole list of state requirements for personnel records. So, this can be confusing because you're trying to match up records that you're required to keep by the law that requires them. So I tried to kind of put this into a simpler format by looking at the stage of your employment relationship. So job advertisements, you should keep a copy of all job announcements and advertisements, including where the ad appeared, because if you're challenged on where you're hiring and whether you're discriminating, that will come in very handy. You'll want to make sure that the ad includes minimum qualifications, job functions, identifies those which are essential, and you're going to pull this from your job description and designate an individual as exempt or non-exempt. You'll want to have a non-discrimination clause and a reasonable accommodation clause in that job announcement. The applications. You should keep at least every application received plus every application resulting in an interview or another part of the pre-selection process for 1 or 2 years. It's one for the applications that you didn't move on to the next phase. You should be keeping an application that belongs to the successful applicant for the duration of employment and then 1 or 2 years. Various agencies use testers to see if you're discriminating, and they will fill out an application to test your commitment to being discrimination-free. And if you throw out those applications and they come back and say, well, I submitted 2 applications. I submitted one with an African-American sounding name. I submitted one with an Anglo-Saxon sounding name. You made an offer to the Anglo-Saxons. Where are those applications? And that is going to trigger some trouble with the EEOC. So if you're doing a background check, you'll want to keep a copy of the authorization that you got from the employee. Also remember that there are a lot of rules out there on the part of states and cities on restricting the use of background information and what records you need to keep. Authorization for a reference check, you'll want to keep a copy. Arbitration agreements, if you use arbitration, that's a contract. You'll want to keep it separately, and you'll want to keep that certainly for the duration of employment, and usually 1 or 2 years after. Interviews. You'll want to make sure there's no discriminatory questions. You should be keeping copies of all the notes that your interview team asks and take. You'll want to make sure that all applications applicants have been asked the same questions. And also, please watch out for salary history questions. More and more states are now passing laws that say you can't use past salary, or when you can use past salary, or when you can even ask about it, and what to do if somebody volunteers that information. So stay on top of that. You'll want to make sure you don't mess that up. Any questions that you ask during the interview have to be job related. Don't ask extraneous questions. And keep those interview notes. You'll want to document any offer you made and what the applicant answered, especially if that individual turns down the job offer and somebody else takes it. You'll want to use an offer letter that confirms that the job is at will. You'll want to specify any post-offer pre-employment testing you're going to be doing. And you want to include the salary or the hourly rate, and any information about whether you're going to be doing a background check and who's going to be doing it. During employment, you'll want to document enough information so that you will have it should you ever be sued. And that includes things like, hey, we'd like you to go take some training in order to get a promotion. And if the person turns that down, you want to make a note of that too. The reason for that kind of record keeping is if somebody comes back later and says, you discriminated against me by not offering me training, you'll want to have something in place that says you did. All performance reviews, keep copies of those. Disciplinary measures, whether they are warnings or suspensions or demotions, you want to keep track of that. Tests taken, promotions offered, pay increases, pay decreases, commendations, and medical information. Keep that separate, of course. If you're doing a voluntary separation, I would do an exit interview. If they raise any kind of discrimination complaints, I would immediately call counsel and investigate that. And of course, keep every single document that you do have. There are special rules that apply to terminating older workers and when you're going to get a signature on a release in exchange for, say, a severance payment. And you'll want to also take a look at what does your state require in terms of conducting a reduction in force, especially if it's a mass reduction in force. And then document destruction. Do not destroy any records once you know or you think you're going to be sued. And that includes, what kind of notice are we talking about? Somebody who comes to you and says, I want to file a discrimination complaint. Notice from an agency that there's been a complaint filed. A question coming in from an attorney alleging that there may have been discrimination, or finally, a notice that a lawsuit has been filed. Do not destroy any documents after that point, no matter how routine and automatic that destruction is. You got to have a way to stop the destruction. And that brings us to our Q&A session.
Excellent. Thanks so much, Annika. Yes, everyone, at this time we can go through some of the questions that have come in from the audience before signing off for the day. So if anyone has any more, make sure you type those in quickly. Annika, the first question we have asks, if someone calls out sick and describes their sickness, does that need to be separated from the regular employee file?
I think the best move is to keep that information separate. Remember that when somebody calls in and it describes the reason they're calling off and they include information, you as an employer have to make a judgment call on whether or not what they're describing might be something that's covered by the FMLA. Because if they give you enough information that you could conclude that they have a serious health condition, for example, then that triggers obligations under the FMLA for you to provide them with notices of their rights under the FMLA and whether or not they're entitled to leave. Anytime you get somebody calling in and describing any kind of a medical condition, that's usually going to trigger the FMLA. And that information is going to be confidential. So I would not stick that call off notice just in the personnel file. I would separate it.
All right, thank you very much. We have just a few more questions here. The next one asked if we have to track exempt employees' hours.
Technically, you don't have to track them. But the problem is if you don't track them and you had them classified incorrectly, you won't have anything to counter any claim that they worked overtime for you when they were misclassified. So if you do keep track, that is kind of a protection. If they never work overtime, if you never have them working more than 40 hours, if they never do that on their own, then it's not much of an issue. But my experience is that most people who are classified as exempt put in more than 40 hours. And if indeed that classification was wrong, you'll want to have the ability to track that. Plus, you're going to want to track, when they take off sick, and you're counting that against, their sick leave allotment and so on. So you really have to have some way of keeping track of your exempt workers too. You may not want to do it with a time clock, but even a notation in the log of what hours they're working would probably be generally advisable.
All right, thank you very much. Our next question here asks, what happens if, when we physically review I-9 documents, an employee says that they have lost or can't find a document previously used over Zoom? Do we have to separate that employee?
I believe the rule is you don't have, no, they have to have documentation that matches the list on the I-9, but it doesn't have to be the same documentation that they initially used when you first remotely reviewed that information. As long as, you can check off the appropriate columns and they have that information. It doesn't have to be the same document. And the same thing holds for when somebody is being re-verified. If the document they had expired, but they have another document that is valid, that is on the same column, then that's fine. As a matter of fact, I believe the rule is that you can't insist that they present the same document as long as they do present the appropriate number of documents from the appropriate columns on that form. And of course, you never re-verify a U.S. citizen, because citizenship is, absent some kind of an odd occurrence, where DHS is basically removing their citizenship for reasons like fraud, which is like extremely rare. The citizenship is going to be permanent until they die. So you never re-verify them because the documentation doesn't expire.
All right, thank you. One more question here asks, how do you determine who needs to know regarding employees' medical conditions and separating medical and personnel file stuff?
That's an excellent question, and usually it's asked in the context of does a supervisor have a right to know about a person's medical information? And usually it's in the context of implementing a reasonable accommodation. That it's a very rare occasion when the supervisor really has a need to know the details of the medical condition. All they need to know is what the reasonable accommodation is. They don't have any inherent right to see that underlying information. So once you've determined that somebody is entitled to a reasonable accommodation and you tell the supervisor about that accommodation, that's really all the information you should be providing. We have determined that the individual is entitled to a reasonable accommodation of X, Y, and Z. And then it's up to the supervisor to implement that, but they don't need the underlying information. When coworkers ask about why, Joe is doing something else than what he did before, the appropriate response from the supervisor is that is information that is not to be shared with those coworkers. So you basically have to find a diplomatic way to say that's none of your business.
All right, thank you very much. Ladies and gentlemen, that looks like the last question has come in, so that will complete today's presentation. If anyone would like to follow up with Anniken, her email address is right on screen there. That is adavenport@businessmanagementdaily.com. All right, thank you so much for being with us today, Anniken, and enjoy the rest of your day, everyone.